Awesome, Nick. So your question's actually interesting. The question stemmed from actually structuring, where somebody was renting out a property to one of their own companies and then using that company to rent it out to tenants. But as we started conversing over this, we realized that a lot of questions actually stem from subleasing. Now, if a person has to let a property out to a tenant, and let's say that you consent, and let's say that you don't consent, so maybe running through both those scenarios, and now there's a subtenant, so this person is paying the tenant and the tenant is paying the landlord. What are the different implications? I mean, there's so many different variations of things that can happen. Maybe just touch on this and run us through a couple of examples of things you've seen.
Perfect. So when we're talking about subletting, what we are talking about is a situation in our law where a landlord, okay, has let a property to a particular tenant, and that tenant has then re-let that property on to another tenant in the circumstances. And that secondary tenant is someone we call the subtenant in the circumstances. And so now the question is, what exactly is the relationship between all these parties? Because they all relate to the same immovable property, but they don't necessarily have the same rights and obligations towards one another in the particular circumstances. And this is another classic case of a situation where we must keep in mind that two distinct contracts exist in the circumstances. Okay, so all of these parties are contracting and have a relationship with each other by means of an agreement, a contract in law, okay? But not all of them are part of the same contract. So there are two contracts. The first one is the primary landlord, which is generally going to be the owner of the particular property. And in our example, that's exactly what it is. And the tenant in that particular circumstance. That is one contract by itself. The landlord and the tenants are the contracting parties. There is then a secondary contract, okay, which exists solely between the tenant and the subtenant in the circumstances. And they are the signatories to this particular agreement. So you can see that in these two agreements, there is one party with the three that are left out. In the first contract, the subtenant doesn't have anything to do with this particular contract. And in the what we call the sublease agreement, the landlord, the owner of the property, actually isn't a party to that agreement in any particular way. And this is important because what it means is that there are rights and obligations in terms of both of these contracts, but they do not extend to all parties. Okay. Say in terms of your sublet agreement, the sublessee has obligations and rights in terms of that contract, but those rights and obligations only extend to the tenants in the circumstances, not to the owner, the primary landlord. So in other words, who do you pay your rent to? You must pay it to the tenant in the circumstances. Okay. Who do you have, if you don't pay your rent, the tenant has the right to take action against the subtenant in the circumstances. It's not actually the landlord that has rights and obligations stemming from that particular contract. Okay, so it must be kept in mind that these are completely separate things. The landlord can't demand anything from the subcontract at all, because what we do see many examples of are landlords coming in and the property's been sublet, and now they're trying to enforce obligations against the sublessee in the circumstances. So say the sublessees, either they're trying to get rental out of the sublessee in the circumstances, or alternatively, the sublessee is not actually looking after the property in the circumstances, and the landlord tries to enforce those obligations. So there's something that needs to be kept in mind. This is a very technical sort of situation, and it can be very dangerous for the landlord in the circumstances, because you obviously, as a landlord, when you're getting your tenant in, you vet the tenant, you make sure that they are creditworthy, you make sure that they're not someone who's going to destroy your property in the process of letting them out. And allowing them to then let on the property again, obviously you as the landlord then have less control or say-so. In fact, you have no say-so over who that particular subtenant is. And that can really put some risk on you and your property in the circumstances. So it's very common that if you have a substantive lease agreement that is drafted between the parties, there is a clause dealing with subletting. Most landlords do not allow a tenant to go ahead and sublet the property without their consent. This is obviously very important for the landlord's purposes. You do not want a tenant who, number one, you don't actually know who they are, but number two, you don't know whether they're going to look after your property in any particular way, taking occupation of your premises without you knowing and without you consenting to it. So a non-sublet clause is very, very common in lease agreements and absolutely critical from a legal perspective to have that clause in that particular agreement, unless you have a specific intention for a particular property. So there are circumstances where, say you're a landlord, you are going to let out a building which is intended for student accommodation purposes, and you have an intermediary who's actually going to deal with the students in the circumstances. Okay, that's a very common structure where this intermediary is basically going to rent your building from you, but they're going to rent out individual rooms. That is perhaps a structure where it would be recognized that the tenant can then sublet. That is a perfectly valid circumstance where that can happen. But if you're not dealing with a particular structure where the intention is to allow a subletting circumstance, it's really recommended that you don't allow subletting for the risks I've already pointed out. Now, I've already gone through the situation. So we've got two different contracts. And what that means is ultimately, the performance, you need to be careful about the performance in terms of these particular contracts. So if your sublessee is not paying your tenant, okay, that has nothing whatsoever to do with whether your tenant pays your landlord, because they're completely separate contracts. Okay, so unless you've written something into your contract that says that performance by your tenant is contingent on the sub-tenant, and I will say I've never seen a clause like that because it would be far too complicated to actually write it in that way. The performances by the parties have nothing to do with one another. So we have seen it a couple of times where landlords come to us, their tenants are not paying, and the tenants basically say, yes, but my tenant is not paying me. And that, unfortunately, has nothing to do whatsoever with the contract that the landlord has with the tenants. The tenants' obligations are to pay the rent. Whether they're getting paid, whether they receive any income whatsoever, has nothing to do with anything. You still have to perform in terms of that particular agreement. So it's important that you keep these particular things separate. The only time that this position might change is when it comes to eviction. Okay, so when we do an eviction in terms of the law, okay, from a technical standpoint, if the landlord is not getting paid and they have to evict their tenant, the person that they are supposed to contractually evict is the tenant in the circumstances, because the tenant has rights and duties in terms of the lease agreement and the subtenant does not. However, when it comes to litigation in South Africa, there is an obligation on the litigating party who institutes the proceedings to include into that litigation each and every person who may be affected by the litigation. So it's a standard rule in law that if you intend to pursue and go for a court order and it might have the prospect of affecting someone else, you ought to include them in those proceedings. So at least they have notice of what is going on and they have an opportunity to put whatever version they want before the court. So the court's very wide in this regard. It wants openness. It wants everyone to be considered before a court can take a judgment in the circumstances. And so whilst from a technical standpoint, if you are a landlord, you've got a tenant and they put a subtenant in, your obligation, if you want to evict, is to your tenants. Your tenant has failed to comply. Whether the subtenant has done anything or not is neither here nor there. But your tenant's failure might put you in a position where you are now entitled to evict. Okay. From a strict contract standpoint, you would only ever need to deal with your particular tenant. However, if you are litigating, okay, it is worth considering that you might have to incorporate your sublessee, not because they are particularly contractually obliged to comply with your lease, okay, or they failed to do anything in the circumstances, but their rights might be materially affected by virtue of an eviction in the circumstances. And so it is absolutely worth considering. Again, this is something that your attorney who is helping you do the eviction is going to consider in the circumstances to say, what do we do with this situation, and have a look at who do we need to include, who do we need to notify that this is happening. Okay, so that's the one aspect, that there might be some sort of incorporation of a sublessee. In all other respects, two different contracts, two separate things that are going on, and they are treated as separately within our law.
Sure. Awesome. Thanks so much, Nick.
Perfect. Thank you, Bruno, and we will see you next week.
Great. Have a great one.
You too. Cheers.